Thank you, Matt. Hello to everyone. So yes, I'm Stephanie. I'm from the Quandamooka people of North Stradbroke Island. So my people are the traditional owners of Moreton Bay and the land and waters around that area. Thanks for having me here today. And I would also like to pay my respects to the traditional owners on the land on which we gather here today. So I will be running through, I'll take a step back. So I'm a master's student here at QUT and I'm doing my master's by research, and this is basically the question that I'll be tackling as part of my research. I have an intellectual property background practicing in that area at a commercial law firm, and now back here at QUT going into this issue a bit more. I also work with Aboriginal and Torres Strait Islander artists in an advocacy role through the Copyright Agency and also through the Indigenous Art Code. I'm not artistic myself, so I can't give any sort of information about that, but I do come from a family of artists, so there's a few different angles at which I'm looking at this topic. So these are the few things that we'll run through this afternoon quite quickly, just the introduction to the research problem that I'll be tackling, how I've approached this question and the research more generally, summary of the initial findings that I have found, and some of the proposed legal and non-legal solutions. I just wanted to note though before I started, I found the talks from this morning and today quite interesting, and I think some of the things that have been mentioned I can actually apply and think about in terms of my own research. And you might be able to see these things as well. So some of the comments by Paul Martin this morning, talking about thinking really deeply about how we buy and sell, how we interact in the market as sellers and as consumers, and the importance of growing sectors here in Australia. And Dr. Shahid's comments about how sometimes definitions don't really work in the markets within which we are operating, and how definitions can sometimes be quite rigid and not actually be representative of the bigger issues that we're facing. And also incentivising good behaviour, which I think was something that was spoken about in terms of the blockchain issues as well. And also about how manufacturing can actually be done here in Australia, but we need to be investing in technology here to be able to do that. So I thought that was quite promising in terms of the issues that I'll be talking about. So more generally, talking about inauthentic art and craft products in the souvenir market. So what is it? What do I mean when I say that? So it really is souvenir products that you might see. You'll see them in Queen Street Mall, at the $2 shop, at the airports, in all major cities, regional centres. So these are products that have an Aboriginal style of artwork on them. They might be a boomerang, they might be a didgeridoo. They might be cups and plates or fabrics with stereotypical designs of Aboriginal work, dots, native animals, spears, Australiana type works on them, giving the impression that these works and that these products were actually made by Aboriginal people. So when we call these type of products inauthentic, or fake is another word that's been used to describe these pieces of these products, is that these products have been made entirely without the involvement of an Aboriginal or Torres Strait Islander person. From design to creation, manufacture and sale, there's been no involvement of an Aboriginal person. So that is the label that I give when I say it's inauthentic. So what we're finding is that a lot of the work usually is manufactured overseas, China and Indonesia, and then imported into Australia by Australian wholesalers. So the market is being driven by Australian businesses. And as I mentioned, the key element here is that there is no involvement of Aboriginal people throughout the entire supply chain. This is despite Aboriginal cultural expression being used to sell the product. You might call this exploitation of Aboriginal culture and expression. It's not a new issue. This has been around for a very long time. There's been early copyright cases here in Australia dealing with this issue. Courts have had to consider the limits of the Copyright Act to say whether or not Aboriginal art could actually be given copyright protection. That has been tested and the court has said yes, even though that copyright works they might be based on pre-existing designs and traditions. If there is a level of originality, copyright protection will extend to those Aboriginal works. So it's not a new issue. It's been an issue that's been given quite a bit of media attention, probably in the last couple of years, and I'll get into the timeline of events that's led us to here. So just to give you an example of some of the works that I'm talking about here, so these are some photographs that have been taken at airports about what inauthentic art and craft products might be. Now, the tricky thing is that that's not to say that all of these products are fake. So the fake products are mixed in with the real products, if you like, and it makes it really difficult for consumers and sometimes even artists to make the distinction between what's real and what's not. That's very problematic. This is an example of some of the labelling issues that we're finding. There have been previous attempts to introduce a labelling scheme for Aboriginal art. Unfortunately, it was laden with quite administrative problems and it didn't move forward. So what we're left is in a situation where labelling is not clear and there's no regulation around that, apart from the fact that it must not be misleading or deceptive. And what does this mean for the consumer? Like, if you're presented with this in the shop, what does it actually mean? It's confusing. Again, here's a little bit more. So on the left, you have some pictures of authentic works, and on the right is the works that are considered to be fake. So on the left, you have artefacts that have been handmade by Aboriginal people, products that have been designed, and products that have been perhaps manufactured overseas, but they've been done under a transparent and fair licensing arrangement. So the involvement of an Aboriginal person is still there. And on the right, you'll see items made perhaps using bamboo, mass production in factories overseas. So this is the approach to the research problem. 2016, there was a campaign launched at the Darwin Aboriginal Art Fair between Copyright Agency, Arts Law Centre of Australia and the Indigenous Art Code. The campaign was called the Fake Art Harms Culture campaign. It's quite clear. Artists were coming to these organisations saying, we're seeing all this fake product in the shops, it's really distressing. Artists are saying it's theft of culture. We've got no control over the way that our designs and important stories are being told. We're also being cut out of the market and financial benefits not coming back to us. Parliamentary inquiry was announced in August 2017 on this same issue. So a lot of my research is in parallel with the inquiry. The inquiry is now finished. It had 162 submissions, public hearings around the country, and a report has just been released on it in December. 8 recommendations were provided by the inquiry committee. So a lot of my research is analysing what the issues are, what are the impacts of fake art, and what are the things that need to be done in order to stop it from coming in or to ensure that Aboriginal people are getting the benefit of their cultural expression. So I'll identify the impacts and the solutions and consider whether the law can protect Aboriginal cultural expression from exploitation. So some initial findings. After going through the submissions, speaking with artists, there are a variety of impacts for Aboriginal people and artists and families and communities. First and foremost, what we're hearing from Aboriginal artists is that, yes, they've been cut out of the market financially, but first and foremost is that the loss of control of cultural expression and what that means to an artist. When cultural expression is tied to identity and who you are as a person, your existence in this country, your connection to the land, what does that do to you as a person when you no longer have control of how that is expressed? Financial impacts for Aboriginal artists and families. Sometimes income from art, from the sale of the art, is the only income that people will have. So the fact that they're not getting that is actually quite detrimental. Again, the integrity of cultural expression. So sometimes for Aboriginal artists in certain communities, different styles and stories can only be told by certain people. They only can be done in certain ways. And so for that to not be adhered to is a major breach of cultural protocol with serious consequences for that person. Not in terms of Western law, but in terms of Aboriginal law. Some of the other impacts that we're finding throughout the inquiry process is for the retailers. So what happens to the retailers who are actually doing the right thing? They are also being disadvantaged by those who have retailers and wholesalers who have high profit margins because they don't have to pay Aboriginal artists to be a part of that supply chain. Consumers. There's been some research done, so Choice did some national surveys, the sample size was quite low. Consumers generally say that they want to engage with products that are authentic. They want to know where the product is from, so provenance is quite an important issue. But one of the things that has come out of the inquiry is that there's no comprehensive national research done. And that is something that really needs to be carried out in order to measure the problem. As we've heard earlier today, measuring the problem and understanding it from that perspective can be very beneficial and helpful in coming to terms of what the right solution might be. Something that's also come out quite strong through a lot of the submissions is how the existence and proliferation of fake art, how does that impact on Australia's national identity? And what does that say about relationships with Aboriginal and Torres Strait Islander people? I've come across some very interesting literature around how souvenirs, in particular, can sometimes be considered colonial treasures. And in that type of instance, it's quite an interesting concept to understand and think about when the majority of businesses who are importing and distributing these products are non-Indigenous businesses. So what does the law say about this? Well, the starting point for this conversation is that there's no comprehensive legislation in Australia to recognise or protect Aboriginal cultural expression or Indigenous intellectual property rights. So a sui generis type of system does not exist here in Australia. So where does that leave us? Well, it leaves us looking to legislation like the Copyright Act, consumer law, to try and address some of these problems. If we go to look at the Copyright Act, though, there's quite limited protection. There's no protection of the style of works, for example. So there's no protection of the dot style of work. So somebody is able to copy a dot style work and not breach copyright, unless it's a substantial copy of that original piece. Consumer law is another issue that's come up quite a bit through this inquiry in terms of the limits of the consumer law and how it can be applied to address this issue. So consumer law is only really concerned with misleading and deceptive conduct in this case. So it's only a problem if representations are made that something is authentic and it's not. That's problematic. But if there is no representation about the product to say that it's real or it's made by an Aboriginal person, even though it's got the style of an Aboriginal style on it, there's nothing wrong with that. It doesn't breach the law. So that's the gap in the law that I'm really interested in exploring further. The interpretation of a representation. In my view, the fact that something's got an Aboriginal style on it, visually, should give the impression that it's made by an Aboriginal person. There was a federal court case at the end of last year. The ACCC, because of the Fake Art Harms Culture campaign and because of the parliamentary inquiry, the ACCC is feeling a bit of heat that they've got to do something. Office of Fair Trade in Queensland did the same sort of investigations of shops, doing spot checks to find out how products were being sold. So out of that, the ACCC took a wholesaler to court and they did find misleading and deceptive conduct in some cases, but there were some cases where that grey area existed. They were Aboriginal products with an Aboriginal style, but there was no labels attached to it to say that it was authentic or that it was real. And in those cases, there's no misleading and deceptive conduct. So the gap still remains. So this is one of the products that would fall into that category of not being misleading and deceptive. Maybe if you can just imagine that little label that's on there, it just says boomerang, returning boomerang, I think. And they're not all returning, they have cultural purposes, and they're not just for returning. So if we take this, for example, it's a boomerang. You would say that the fact that it's a boomerang is a representation of it being Aboriginal in the first place, and the styles in it are giving the impression that it's Aboriginal. Under the law, this would not be misleading or deceptive. So this is permitted. In my mind, I think that's wrong, and it needs reform. So these are some of the proposed legal solutions that have come out of the inquiry. So some of these things have been proposed by different lawyers. I know that Allens Linklaters have been involved in the consumer aspect of this. So the first amendment, one of the strong amendments to the consumer law would be to prohibit the manufacture and sale of inauthentic art. So to stop this stuff from coming in, unless it was actually made by an Aboriginal person or it was made under a licence agreement with an Aboriginal person. So it could still be made overseas, but provided that there's a fair and transparent licence agreement in place, that would fall within the ambit of that amendment to the consumer law. So the ACCC is a regulator. They have limited powers because of the way that the law is currently drafted. They're a little bit hesitant to support this amendment at the moment. Their view is that they are really about broad economy-wide principles of fair trading and preventing misleading and deceptive conduct. They say that they're not able to provide and deliver on specific areas regarding the safeguarding of Indigenous culture. Some people have said, okay, well that's fine, ACCC, but what about the work that you've done in specific areas like telecommunications, shipping liner industry, door-to-door sales? Some people say, well, there is scope for the ACCC to have a role there. And in the long term, sui generis legislation is what is needed. Short term, what we're hearing from the submissions, and particularly from Aboriginal and Torres Strait Islander artists, it just needs to stop. There is no other option. And one of the ways it could stop would be for this amendment to the ACL to come through. So other proposed solutions, there have been a few mentions throughout the submissions to the Trip Council's management of the TRIPS agreement, but there was recognition through the submissions that discussions around traditional knowledge have been blocked at the moment within Council, so that's a really difficult process in terms of the international approaches to be made. Again, the use of blockchain to create digital labels, very relevant to the discussions this morning, I thought. There is a current pilot between Desart Copyright Agency and the Department of Communications and the Arts, so a federal department, funding a pilot test to see whether a blockchain can deliver in helping to create those digital labels to give consumers a bit more confidence at the point of sale. And I think something that was also really interesting, was it Darcy from this morning? How he mentioned how it not only can support the consumer, but on the other end of the scale, giving power back to the artists. So the artists who are engaging with these arrangements, where sometimes there is exploitation occurring, if they are actually aware of the chain of title of where things are going down the line, it actually puts the artists in a better position as well. Other solutions, education for artists, consumers and retailers, helping people to understand the right questions to ask, to go into the shops, to be confident to say, where is this product from? Who is the artist? What are the royalties going back to the artist? Where did you source the product from? And more broadly, at a national level, the introduction of a national Indigenous Cultural Authority. So this has been something that's been kicking around for quite a few years. There's been ongoing consultations around what that might look like. Is there a body that could assist in the licensing arrangements? Is there a body that could act as a watchdog for fake art products? So that's where I'm at the moment with the research. I think one of the interesting things that I will come across, and what I'm finding with a lot of submissions, is around the use of definitions and language. So when the inquiry looked at the issue, they were really concerned with definitions around authentic. What's authentic and what's inauthentic? Categorising things and giving things specific definitions. But when you contrast that with the responses that are given by Aboriginal artists and communities, how they describe their work and how it is totally entwined with who they are as Indigenous people, the definitions of authentic and inauthentic really do not suffice. And I think we are coming up against a clash of cultures when trying to address this issue. Thank you.